public interest, upholds the values that are within the Constitution as well, is found to be to pass the financial probity assessments. Thank you, Chair.
Are there any professional, financial, political, or personal matters in your background that you consider that it will be prudent for the committee to know, for they may have an impact on your independence and impartiality?
No, Chairperson. As I previously mentioned, I do sit on a couple of boards, and there's continuous checks on my background on legal issues, on financial issues as well. The Prudential Authority as well also does those regular checks on me.
So are you involved in any advisory, consulting, legal, academic, commercial, political, or civil society work that may create an actual or perceived conflict of interest?
No, Chairperson.
What would you do if appointed when the regulator has to deal with a matter that involves your former employer, your client, your funder, your political associate, your business partner, your family, or anyone you would have had a close relationship with in your past? How would you deal with such a situation?
The first point of call, Chairperson, would be to disclose the relationship, whether it's a previous employer, a previous relationship, or a current relationship that I hold, and disclose it fully, the full extent of it, so that an assessment can be made as to my judgment and whether it would be impaired on the matter.
Thank you. Honorable Glover.
Thank you very much. Good morning, Mrs. Mvandaba. Am I saying it right?
Yes, thank you.
Welcome here with us today. I don't have many questions for you. It's just for more clarification that I need on certain things. I do see you have a very strong audit style CV, correct? Legally, not so much. What I would want to find out, with your CV being very strong in the audits, risks, finance, boards, you mentioned you're on commissions. What direct experience do you have with POPIA and PIA, privacy of governments, or access to information rights specifically?
Thank you so much for your question, member. So as I previously mentioned, I do consider myself having expertise within governance. And sitting on the boards and also advising audit committees and having an audit background means that I am often charged with the responsibility of overseeing the enterprise risk management framework. Legal and compliance forms part of the ERM framework, and then PAPAIA and PIA would then fall under legal and compliance. I can give you maybe one example, a recent example. On one of the public entities where I chair the Audit and Risk Committee and I'm on the board of, we have a separate meeting that deals with PAPAIA because of the nature of the information that they handle. Sorry. The nature of the information is, it's in the healthcare space. The nature of the information are people's IDs and sort of healthcare information, which is considered to be special information. And so we have to have separate meetings where we deal with any breaches, any security concerns, and that kind of thing from a PAPAIA perspective. Thank you.
Are you able to name the conditions for lawful processing under the POPIA and explain which you believe are the most important for large financial institutions?
Can you please repeat the question?
Are you able to name the conditions for lawful processing under POPIA and explain which two you believe are the most important for financial institutions?
Sorry,
I can
one more
assist you
time.
in terms of accountability,
Yeah.
processing limitations,
Yes.
safeguard security systems, those type of things. Those are what I mean when I'm talking about processing under the POPIA.
Okay, which ones need to be?
Which would be the most important for yourself? If you can explain a little, elaborate just on a couple of them, if you're able to.
Sure. So I think what would be important for me would be, and here I'm looking in conjunction with the King Code, it would be when it comes to safeguards, who's the owner of the process. and sort of the end owner then speaks to how the process flows. It would be about holding the accounting officers responsible for any data breaches, and making sure that the boards also are responsible.
Thank you very much. How would you translate your audit and your risk committee experience into meaningful oversight in the regulatory enforcement work? If you can give me maybe one concrete example.
So I think with the phase that the regulator is moving into, with being a public entity and coming onto the radar of the Auditor General and having to comply and apply the PFMA, the experience that I would use to bring to the regulator would be around setting up internal controls and financial systems to ensure that they comply with Treasury regulations and the PFMA.
Sorry, one of my questions was asked by the chair. He covered me on one basis. I just don't want to waste your time. The information regulator, and this is my last question, ma'am, has a very strong legal mandate, extremely strong. And you are not a practicing attorney or lawyer. And where do you believe you would add the most value? And you have mentioned your audit, and I just want to know your one skill that stands above the rest, that you say, this is what's going to put me above any of the other applicants that do have law degrees. What would your one skill be that you say trumps all others?
I would say twofold. The ability to distill the complexity that comes with the legal framework into actionable, practical processes and systems within an organization. So moving into an implementation phase, what does that mean for business as usual? That would be my skill.
Thank you very much, ma'am.
Thank you.
Thank you. Tau.
Thanks, Chair, for the opportunity. Good morning, Ms. Mvanda.
Vandaba.
Vandaba. Yes. All right. Ma'am, why are you interested in serving as an information regulator?
Thank you so much, ma'am, for your question. My interest relates to, and most of my corporate experience is in private sector, and my exposure to public sector has come sort of in the later part of my career, and that's because of this desire to serve my country. And wanting to be in public service. So that's the first side of it. The second side of it relates to the interest when it comes to data, to digital literacy, to AI, and to all the things that are coming into effect that I think that we're grappling with a little bit as a country. And so I would love to be part of the grapple and part of the solution as well. Thank you.
Thank you. What will you do if an executive or parliament or a political party or one powerful private entity or individual attempted to influence the outcome of an investigation or enforcement matters?
I think it's worth mentioning that because I'm a member of the South African Institute of Chartered Accountants, we are bound to act with integrity and honesty at all times. And so we are bound legally to always be fit and proper to maintain our designation. So I already come with that. So if someone is trying to influence an investigation, it would be, I think, prudent to disclose that, to the chairperson or whatever sort of arsenal that I've got, to disclose to that person that this is what is happening, but allay their fears that they have not influenced me.
Many organizations treat POPIA compliance as a tick box exercise. How should the regulator shift compliance towards a genuine culture of privacy and accountability?
Thank you, ma'am. I think that it's so easy for organizations to say we have a POPIA policy, right? But what's important for the regulator is to audit the controls, not audit the policies. So how are the policies implemented? I think a way that we could leverage maybe off of the work that's already done by the AG would be to hold the accounting officers accountable for the implementation of the controls and the AG signing off on the implementation of the policies adequately.
What is the biggest threat to personal information in South Africa today?
Okay, so I would say the biggest threat would be cybersecurity, so things like ransomware. It would be employees that are not trained enough to handle the information. It would be the use of the information for commercialization that has not been approved by the individuals. So information that is stolen and used for for commercial reasons. And then it could be harm as well, like harming people if you've got their address, identity theft, that kind of thing.
Okay, Chair, my last question will be why it is important that the same institution deals with both the protection of personal information and access of information.
Thank you, ma'am. As I mentioned earlier, I think it's two sides of the same coin, where one can be seen, or both can be seen as a human right, the right to information, but the right to privacy as well. And I think that instead of dealing with it in silos, it's important to look at it, that it be looked at by the same organization to ensure that there's a balance in how it's looked at.
Thank you, Honorable Murray.
My chairperson, welcome, ma'am. I just want to. Okay. Good morning. I just want to check with you. Why would you want to serve on this portfolio? Because you are on so many boards. What is the reason for you for applying for this position? Just curiosity.
Yes. So if you would note the tenure of some of my board positions, they're coming to an end in September 2026. And so when I'd applied, it was with that in mind. So I'm not trying to overcommit. It's because at least two of them are coming to an end in the next 2-3 months.
Okay. So what strengths would you bring to this position?
So outside of the fact that I'm extremely hardworking, it would be, as I mentioned to the honorable member before, that my ability to distill complex information into simple, actionable solutions, systems, internal controls. I've got a lot of experience in oversight and guidance and providing guidance. And I think the ability to make sure that the end user and the person that is served by the information regulators, the South African citizen, making sure that that is not forgotten at any point in the process.
Okay, if you get a position, what is your vision for this information regulator over the next 5 years?
Sure. Okay, so I think firstly, if I think about what was included in the annual plan and the strat plan, it would be ensuring that, seeing that it's now a Section 3A entity, ensuring that it complies with the PFMA and with Treasury regulations, getting clean audits from AGSA, making sure that procurement isn't an issue, which is always an issue for AG audits. It would also then be moving into further digital literacy programs that can be given into the community, but understanding that as much as moving digital cannot be the only way that we engage with the South African citizen, because so much of the population does not have access to data and to smartphones. So setting up maybe centers where people can, maybe through NGOs, where people can engage with the information regulator and log complaints or log requests for information. So making sure that digital is not the only way that we're going.
Just a question that I would like to know from you is that every day we get annoyed by all these phone calls that we are getting. And it is all about insurance and things, and your information are being given, don't know by who. Né? And these companies are calling you about insurance, about tracker, and all these things, getting your information from somewhere. How would you deal with companies that is taking people's personal information for use? How would you deal with an issue like this?
I think it's Section 63 of Papaya that says that companies have to specifically use the opt-in methodology. So my first question would be, can you provide proof where these people opted in to receive these calls or information from you? And if they cannot, then that's where the problem lies.
And then I would like to know, how should regulators address cross-border data transfer? Because we are working with Lesotho. I'm from Free State, so we have this communication with one another. How should we address this cross-border data transfer?
So I think that if we keep in mind the principle that we are trying to purport here, which is around protection, the safety of people's information, but also access to information, and working with other institutions, other governments as well, making sure that the principle is the same across the board. We cannot close borders because I think closing borders, even digitally, would harm SMMEs in the country. So we need to be as open as possible, but also make sure that our portal is as integrated as possible and less cumbersome for small businesses and medium businesses to do business across the border.
Okay, my last question would be, how would you engage with technology companies regarding compliance obligations?
Okay, so if I'm thinking about a technology company and how I'd engage with them around compliance, it would be first around what their policies are, how their policies are drafted, and what do the minutes that are reflected in the IT steering committee, if they've got one, what do the minutes say? How do the minutes support what the policies say? Ensure that they are in a position where they're disclosing information almost on a voluntary basis, and it's not us going after them for the disclosure of information from that side. And then from the Papaya side, making sure that they only use the information that they have for what they need it, and when they don't need it anymore, they destroy it.
Thank you, Chairperson.
Thank you so much, members. Section 55, subsection 1 of the Constitution accords powers to the National Assembly to enact, amend, or reject any national legislation. So, with regard to Paia and Popia, what would you advise Parliament to do with those enabling legislations to strengthen the mandate of the information regulator?
Thank you, Chair. So I think in conjunction with um, with accepting and approving the two pieces of legislation, it would be to give the regulator a bit more in terms of power and teeth when it comes to fines and when it comes to consequence management for entities that do breach the policies or the legislation. I think there also needs to be maybe some concession from National Treasury side that would allow the regulator to withhold a portion of the fines so that the regulator can also continue as a going concern and maybe grow and set up maybe a task force or bring in the internal audit or forensic functions in-house. Yes, Chair.
Thank you so much, Ms. Mvandaba. That marks the end of the conversation with the members. You can take a big sigh.
Thank you so much, Chairperson, and thank you to the members.
We want to thank you for having raised your hand when we were looking for patriots to raise their hands and contribute meaningfully to the public service. We thank you so much for that. We are going to, after having done with interviews, have a committee meeting, deliberate on the candidates, recommend one candidate for part-time, recommend one candidate for full-time. then adopt the committee report and submit to the National Assembly. The National Assembly is the one that is going to deal with the recommendations of the committee. Yesterday, we said to the candidates that the committee has taken a resolution to start earnestly the process of filling the vacancies that are going to be available in November. The current members of the regulator's term is ending in November. So we are still going to deal with such matters during this year. So we wish you well and we wish you safe travel back home. Thank you. Honorable Club.
Chairperson, just as a procedure, Honorable Breitenbach has asked apology. She has to now be at Rules and Committees or Rules Committee at 10 o'clock, and unfortunately won't be able to join.
That's fine. That's fine. That's
Thank you,
fine.
Chair.
That's fine. Honorable Matafa is supposed to be on the way also. Yeah, it's very, very full. Mr. Mulawoods, switch on your mic. Somewhere there.
Yes, thank you. Sorry about that.
How are you going to be a member of the information regulator when you can't even operate a mic?
I think I'm a little bit,
Nervous.
nervous, but
No, just drink water and relax.
no, thank you for the
It's
advice.
just a conversation.
No. Thank you about that.
It's just a conversation. Well, good morning, Mr. Mlawudzi, and welcome to the interviews for the filling of vacancies in the information regulator. My name is Xola Ngola. I am the chairperson of the Portfolio Committee on Justice and Constitutional Development. In front of me is Honorable Motaung, Nonoma Sondo. Behind her is Honorable Marais. On her right is Honorable Klopper. These are the members of the committee. There's a lot that is not here, engaged in other serious parliament business. So you are lucky that there is only 4 of us, otherwise you would have been made to answer questions from 11 people. It's one of the advantages of you coming here today. On my left is Mr. Ramano, the committee secretary. On your left is Magadana, the executive secretary. Behind her is Mr. Dano, the researcher, committee researcher. With the camera there is Raja, media and communications. Behind her is Gillian, the researcher. On her left is Miss Silkstone, the content advisor, and she has a birthday today.
Okay.
Yeah. So, but you are going to be made to answer questions from members. You are given now an opportunity to introduce yourself fully.
Okay. Thank you, Mr. Chairperson. And I think it's a great honor to be invited today and be able to participate in this interview. I think it's a good thing that I was nominated out of a pool of candidates that had applied. I don't take that for granted. I think there's an opportunity for me to be able to contribute meaningfully into the country and also into the information regulator sector. So I think my name is Moses Isa Mulauzi. I was born and bred in Limpopo. I'm coming from a small town called Musina. Musina, it's 12 kilometers away from the border between South Africa and Zimbabwe. I think if you look at my CV, I've studied the law. I have an LLB degree. I'm currently doing my master's degree in corporate law. I have over a decade of experience with the United Nations High Commissioner for Refugees. Within that decade, I've worked, I think, 5 years in the operations, meaning that I was working in South African activities as far as refugee protection is concerned, working concurrently with the Home Affairs, refugee reception offices. And the last 5 years that I worked with UNHCR, I was in the regional office, where we were mostly doing oversight work. I think we were responsible for 16 countries in the region, where our role was merely to provide oversight and also technical support to country operations. So it has actually assisted me in gaining perspective in as far as human rights is concerned. As we all know that refugee rights are also human rights. So I think working in the region has gave me exposure into different human right environment. I know we're dealing with information regulators, but I think privacy, it's also some of the most important human rights element that shouldn't be overlooked. So I think maybe with that, that's the introduction, the brief introduction that I wanted to give you. But before I close, I think I'm currently in alternative dispute resolution. I've graduated with AFSA. AFSA is the Arbitration Foundation for South Africa. I think I do ad hoc mediation and court annexed mediation in order for us to be able to assist people to find cost-effective solutions. It doesn't necessarily mean that I'm diametrically opposed to litigation, but I'm merely of the view that if people can find a resolution, they should be able to look at all the avenues I don't think the court processes can resolve all the issues, but there are certain issues that need to be resolved through the court processes. But there's also an avenue through alternative dispute resolution, which I think is gaining momentum. So I think I'll stop here. That's in a brief who I am, and those are the accolades that I have achieved throughout the years in my career. Thank you.
Thank you. Do you believe that you are a suitable candidate? And if the answer is in the affirmative, why do you believe so?
Well, I do believe that I'm the suitable candidate for this position because of my exposure in human rights, as I've indicated. But I don't only have human rights credentials, I also have governance credentials. I've worked in the region. I do have a sense of how the misuse of information can adversarially affect individuals, especially if it's used inappropriately. So I think, with that being said, the priority would be to contribute to such a fundamental human right where people's privacies are protected. As we all know that if information is used or it's been abused, that might create a lot of challenges for the individuals. I've learned throughout my years with UNHCR that if you disclose information about individuals, that might exacerbate some of the challenges that they are currently facing. Some of them have ran away from their countries of origin. So it's very important for us to be able to handle sensitive information as such, and we treat it with the respect that it deserves, because if it falls into the wrong hand, it might contribute to the challenges that people are actually exposed to. It might result in them being discriminated. It might result in them being exploited. It might even result in them being killed. So I think coming with that perspective and also understanding that privacy is not only a compliance issue, but it's a human rights issue. I think that does put me in a position to be able to assist the committee. Thank you.
Are you available to serve full-time or part-time?
Yeah, as I've indicated, I was available for either roles, but I saw in my invitation I was only shortlisted for the part-time role, which I don't have any objections to.
Otherwise, you are available for both.
Yeah, I am available for both.
Okay, we'll keep that in record.
Okay.
OPIA requires that members of the regulator must be South African citizens. Are you a South African citizen?
Yes, I am a South African citizen. I was born in Musina. It's in Limpopo. But yeah, in short, I am a South African.
Do you have a dual citizenship?
No, I don't.
Even that of the nearest Zimbabwe from Musina?
No, I don't. But I do treat, since my migration is very complex, so it happens that there are people that are divided by the border, but we somehow have relatives in both countries. Those are the dynamics of border towns. But yeah, but I am a South African, but I do have relatives in both countries, yeah.
Is it? Okay. So, do you consider yourself appropriately qualified?
Yes, I think I do consider myself appropriately qualified. As I've indicated, I have over a decade of experience with UNHCR, which is an international organization. It did provide a platform for us to showcase our work. I think for the first 5 years, I was working as a protection associate. I was responsible for protection issues in South Africa. And within the last 5 years, I was in the regional office, like where we were providing support to 16 operations in the region. So I think that experience somehow does put me in a better position to be able to provide the service that the Commission requires.
Okay. Do you have any background matters that may affect your impartiality, your integrity, or your ability to do your work if appointed? Whether they are professional, whether they are financial, whether they are political, whether they are personal.
Well, at this point, I'm not sure how to answer that question. But as far as I know, I don't. But should it happen that the situation arises, I think I will be transparent and disclose, if appropriate, maybe possibly recuse myself from the processes or the matter that requires me to do so. But as far as I'm concerned, I don't.
Okay. Let's say you are appointed. Then a matter arises that the regulator must deal with. But this matter involves either your former employer, a friend, a funder, a client, or anyone you may have had a close relationship with. How would you treat that situation?
Well, I think from the onset, as I've indicated, I believe that what makes the commission, the regulator, unique is that they're independent, they're impartial. So, irrespective of who is involved, I think I should be able to carry my duties and responsibilities to the best of my ability, unless if the matter is so severe to a point that I, there's a perceived conflict of interest, then I might be required to recuse myself from that particular matter.
Are you involved in any advisor, consulting, legal, academic, commercial, political, or civil work that may create an actual or a perceived conflict of interest?
As I've indicated, currently I'm assisting people with alternative dispute resolution services. I think largely because when I was with a commission, which is the United Nations High Commission for Refugees, I found that assisting people in terms of finding an alternative way to resolve their dispute has been something that we were doing, and I was leaning towards that. But I don't think at this particular point, irrespective of what happens, I indicated that I think I'll be professional. I'll be able to provide my services, unless if the regulator requires me to step away from those activities. I think I can consider doing that.
Thank you. Honorable Clover.
Good day, Mr. Malazi. How are you doing today?
I'm good, and you, sir?
Good, good. I've just got a few questions for you. I do apologize if I repeat something. My laptop froze. I tried on my phone to take notes and then that wasn't working, so I do apologize. I just want to make sure you're currently admitted as a legal practitioner. Are you still preparing for board examinations?
Or currently, I'm not admitted as a legal professional. However, I have my LLB degree. I'm currently doing my master's degree. I have two postgrad diplomas, one in labor, the other one in drafting and interpretation of. I also did PLT, and I think with time I might consider writing board exams. But like for now, I'm leaning towards alternative dispute resolution, because after graduation I worked directly for UNHCR, so I didn't go through the processes of being admitted. But I'm not like I said, I'm not diametrically opposed to litigation, but I just feel I'm leaning towards ADR more. Thank you. I hope that answers your question.
No problems at all. Your CV is strong on human rights, and I would like to know just what practical regulatory enforcement experience would you bring to the information regulator as such?
Well, I think, as I've indicated, throughout my career, I've been dealing with very sensitive information, especially information that asylum seekers and refugees do provide. I think it's very important for institutions to have standard operating procedures on how they deal with information and how they deal with how they're sharing information with each other. Because if information is in the wrong hands, that might adversarially affect individuals that are involved. So I think also something that maybe I might bring is obviously awareness is very important. I see that's something that people are not really aware on their obligations, especially when it comes to informations and privacy. So I think that's something that I can also be able to bring into the fold. And also sensitization campaigns where we are educating the public about the importance of privacy, especially with what's currently happening with artificial intelligence and social media, where people are obviously sharing information that they're not supposed to be sharing. So those are some of the activities that I can think about at this particular point.
May I press you a little bit harder on that one to more enforcement? What practical regulator on enforcement experience would you bring? Not so much on the sensitization and education, but more on enforcement.
Well, I think, as I've indicated, privacy it's a human rights issue. So I think people that do violate those rules, I think they need to be able to understand that there are consequences. It can be civil consequences, it can be criminal consequences. So those are the two that I can think about at this particular point in time.
You have a lot of skills and a lot of experience. What I would want to know is why would Parliament or should Parliament consider someone's experience is very adjacent to that of the mandate rather than a candidate with direct experience of PIA, data protection? I would want to know, I want you to sell yourself. Why is your skills then more pertinent than someone that has that experience specifically with what the regulator deals with?
Yeah, well, as I've indicated, obviously there's an intersection between what the, the the regulator does and what the other institutions do, especially when it comes to specific information that is available to the organizations, and also how they should be able to deal with that information. As I've indicated earlier, asylum seekers and refugees are some of the most vulnerable individuals. And obviously, we understand that some of their sensitive information might be the results of them being persecuted even further. So I think that also links with how the regulator is working, because they are also working with sensitive information and they're trying to ensure that sensitive information is protected and people are not exposed to harm due to the misuse of that information. So I think it does play a role in a way, even though it might not be directly or it might not seem like, but I think it does play a role, and I see the linkages in that.
Thank you so much. I've got one more question and then I will be done. Is there any matter, POPIA or PIA matter, that you've personally handled, advised? I know you couldn't litigate, but any matter that you've advised on specifically, maybe even just one example of a POPIA or PIA matter that you advised on?
No, unfortunately, I don't.
Thank you so much for your time, sir. Appreciate it. Thank you,
Thank
Chair.
you very much.
Honorable Mtau.
Thanks, Chair, for the opportunity. Good morning, Mr. Mlauzi.
Morning, morning.
Mr. Mlauzi, why are you interested in serving as an information regulator?
Thank you very much for that question. As I've indicated, throughout my career, the promotion and protection of human rights has been very central. And as I've indicated, information is not only a compliance issue, it's a human rights issue. So I think me being someone who's particularly interested in human rights matters, I think I would be a good fit for the information regulator, and that's probably part of the reason why I applied. But over and above my skill set, I think I've always been passionate about the promotion and protection of human rights. Thank you.
What is the biggest threat to personal information in South Africa today?
I think we are well aware that artificial intelligence is currently at the forefront of what we're doing. So that's something that needs to be used carefully, because if it's not used carefully, that might create a problem. But that doesn't necessarily mean that we have to take away from all the upsides of artificial intelligence, because it can be able to create bias of some sort. But I think also other elements that are affecting the country at this particular moment are identity fraud, there are cyber securities. So those are the issues that I see as being the threats, and how the social media is currently being used with no regard for. I'll give you an example. You find that someone's loved one has passed away, and unfortunately, before the family is even notified, you find the information readily available, circulating online. So those are some of the issues that are currently a challenge, according to my own observation. Thank you.
What will you do if the executive or parliament, a political party, or a powerful private entity or individual attempted to influence the outcome of the investigation or enforcement matter?
Well, as I've indicated, I think the effectiveness of the regulator lies strongly on it being independent, and if it's not independent or it's impartial, it can be influenced by politicians, by powerful organizations. That might defeat the purpose of why we have a regulator in place. So I think the most appropriate things is for me to be able to report such intimidation tactics or coercion. But I think all in all, the regulator should be independent and impartial without fear or favor. So I think I'll stop here. Thank you.
Okay. What strategies would you use to encourage compliance with POPIA by both public and private bodies?
Yeah, well, I think with that, as I've indicated earlier, sensitization is very important. People need to be able to understand their roles and responsibilities as far as information is concerned. I think sensitization in terms of awareness campaigns, and also strengthening the issues of enforcement mechanism, so that people are aware that this is not just a paper tiger, but it does really have some teeth in terms of enforcement. So I think focusing more on trying to get the buy-in of the public through whether it's advertisement, whether it's information campaigns, whether it's a curriculum in institutions of learning. So I think those can be something that contribute towards the effectiveness of the regulator.
My last question, Chair. POPIA requires responsible parties to secure the integrity and confidentiality of personal information and to notify the regulator and affected data subjects when there are reasonable grounds to believe that personal information has been accessed or acquired by an unauthorized person. How should the regulator assess whether an organization responded adequately to a security compromise?
That question was fairly long, but Maybe do you
Yes,
want to rephrase
can I
that?
repeat?
Yeah, thank you.
Okay. POPIA requires responsible parties to secure the integrity and confidentiality of personal information and to notify the regulator and affected data subjects when there are reasonable grounds to believe that personal information has been accessed or acquired by an unauthorized person. How should the regulator assess whether an organization responded adequately to a security compromise?
Well, I think I did capture the question very well, and I'll attempt to respond to it to the best of my ability. So I think, as I've indicated earlier on, obviously there is standard operating procedures that guides how the regulator has to act and respond in terms of a specific breaches. So with regard to that, I think obviously relying on the SOPs and the Act and other acts of Parliament, of course, that's maybe possibly what might be able to assist in terms of the assessment, but also a preliminary investigation might also be able to assist in terms of trying to understand what are the challenges, where did the breach occurs, and also looking at possible ways of how they can be able to rectify that.
Thank you, Chair.
Thank you, More.
Thank you so much, Jefferson. Good morning, sir. I just want to hear from you is that you said that you've been working with the High Commission for a very long time now. And working with the High Commission, you come across a lot of politicians on a daily basis. If it is your turn to deal with these politicians, how are you going to do it? Because you know them on a personal basis.
Well, I think in my first 5 years, I was obviously dealing with politicians on a local government level because I was based in Limpopo where we were doing operational work. And also, I think we didn't encounter any challenges because those were people that were willing to listen to the issues at hand. Where, as the Commission, we have a ground to be able to substantiate issues on behalf of the persons that we serve, they would be able to listen. But if it happens that we are obviously meeting people that are not cooperating and which I haven't encountered in the past. So I think maybe the issue of sensitization might be able to assist in terms of either our politicians having an understanding of what's the role of the regulator. I think for me, I feel before we engage into issues that might further exacerbate whether it's the working relationship or whether it's the people that we're trying to serve, if there's ground for that in terms of them having to understand that this is what the regulator does, I think enforcement might not be a challenge. But again, that could be my belief. But I haven't encountered situations where people were unwillingly refusing to comply with legislation. But I haven't came across that. Thank you.
I can hear you are very passionate about human rights and negotiations, mediations, because that is your passion. I can hear you talk about it. How will you implement that into the regular, this thing that you are going to now? How will you put them in there? How
Yeah.
would you?
Well, as I've indicated, I've gained a lot of experience in this sector, and I think not only because of any other maybe motive, but I think, like I've indicated, privacy is also a human rights issue than a compliance issue. So I think it's not far-fetched from the work that we were doing. As I've indicated, we were working with sensitive information, so that's more or less the same information that the regulator deals with. And also, I think from my role at the Bureau, it was more of an oversight role, which allowed me to provide assistance to different operations. So I think what the regulator does and what we were doing, somehow they have linkages, because I don't think there's any services that can be provided without information being at the forefront of what's required and what's done. So information, like I said, the most important thing is how it's being used. If it's used appropriately, then that might be able to contribute positively to what the regulator is trying to achieve. But if it's not used appropriately, then it can be able to put people's lives in danger, and it can be able to expose them to a number of vulnerabilities.
Okay. A large company repeatedly ignore enforcement notice. How would you approach the matter? I want to make an example. Is that if you look at the Competition Commission, they had collusions during 2010 World Cup, cement companies and all that. Then you had the collusion of bread companies coming together asking the same price. How would you deal with big companies like that? Because if you look at these big companies, they know because they are big, they're just going to pay a fine at the end of the day. How would you deal with a company like that, big companies like that?
Well, I think, like as I've indicated earlier, we will require guidance from either legislation itself or the standard operating procedures. We will also look at decided cases on those specific matters. How has the regulator dealt with those cases in the past? What are the sanctions that are available, especially looking at the transgressions that we're looking at? So that might be able to assist us. But if it happens that none of those speaks directly to what is currently happening, I think it's appropriate to seek guidance from other senior members in the team.
Okay. Government departments suffer a major data breach affecting millions of citizens. What should the regulator immediate response be? If you look at SASSA, last year, two young boys of Stellenbosch went into the system and they could hack the system because they could see people were taking all the ID numbers of people that is born in 2006 in that year, that month, and they applied for SASSA. And basically, the people of the IDs didn't even know that they have applied for SASSA. What would your, as a company, as an organization, what will your response be to that immediately?
Yeah, well, I think ideally it would have been great to have prevention, obviously, than to having to deal with the aftermath. I think prevention would have been able to consistently train the people that are obviously dealing with information, sensitive information, like your IT teams and whatnot. But if the issue has already happened, like you've indicated, I think an investigation can be able to assist as to what transpired. Is it something that was deliberate? Who was involved? Who was responsible? Could this have been prevented? If not, what were the issues? And also, again, going back to the Act, what are the possible sanctions for such breaches? And also, again, looking at the reputational damage that is obviously involved in such matters. So I think, but for me, ideally, it's better to prevent than having to deal with the aftermath. Thank you.
My very last question is that if you get a position, what is your vision for this information regulator over the next 5 years?
Well, I think for me, obviously, we'll have to go back to what has been working within the regulator, what can be changed, and what isn't working. I think having a holistic picture can be able to give us guidance as to where are we going to go from here. I think it's very difficult to come and say this is the direction that we want to take before we have an assessment of what's currently working and what's not working. So I think that will also require us to have consultation with different stakeholders to have an understanding of how can we be able to improve. We engage a number of people that might be able to assist, people that are very familiar with our mandate and those that are not familiar, and then we can be able to come up with a proposal, whether it's a draft zero or a finished product. But I think that will be the basis, and that will be the start of maybe a great project, but by trying to assess where we are. Thank you.
Thank you.
Thank you, members. Mr. Mlaudzi, Section 55, subsection 1 of the Constitution accords powers to the National Assembly to enact, amend, or reject national legislation. To improve the work of the regulator, how do you think that Parliament can use those powers to amend the POPIA and PAIA for purposes of improving the work of the information regulator?
Yeah, well, I think, thank you for that, Chair. I think I will link my question, your question with the last response that I provided from the last speaker. I think, again, we'll go back to consultations and discussions with obviously Parliament with a view of trying to understand what's currently in place, what's working and what's not working. And then with that, after deliberations, that's when we can be able to focus on what's obviously not working. But if it's working, this might be able to provide to the holistic picture of the regulator. So I think that's how I'll respond to that particular question.
Okay, thank you, Mr. Mlaudzi. That marks the end of your conversation with the members. We want to thank you for raising your hand to contribute meaningfully to the public service. We are going to have a committee meeting for deliberations after the interviews. After that, we adopt a committee report that recommends names to the National Assembly. Then the National Assembly will process that and adopt. So we are going to keep contact with the candidates through our committee secretary. We wish you well, and we wish you a great travel back home. Thank you so much.
Thank you, Chair. As I've indicated in my opening remarks, I do appreciate the opportunity to come and share my views and probably cross-fertilize ideas with you. And I don't take this lightly. As I've indicated, I've seen and heard about a number of people that had applied for this position who unfortunately couldn't be in this room. So I appreciate extending the invitation. And I hope after your deliberations, you will let us know as to what's the outcome, and then we can take it from there. But without wasting anyone's time, I'd like to thank you guys for being kind and obviously thanking the members who couldn't be here.
Yeah.
Okay.
Thank you so much. Travel safe.
Okay, thank you very much.
Members, the last candidate is still on the way from the airport. So they said they can take about 10 minutes. They got delayed by traffic. So let's just adjourn and resume at 11:45. good what now? Still good morning. Good morning, Ms. Mesha. We decided to give you a cool-off period because we understand that you may have come here rushing, particularly knowing that we are waiting for you. So we deliberately allowed you to cool off so that you are able to give us your knowledge the best you can. Welcome to this interview. We are filling vacancies in the information regulator. My name is Xola Nqola. I am the chairperson of the Portfolio Committee on Justice and Constitutional Development. In front of me is Honorable Mutawung. On her right is Honorable Matafa. You can see that the way he's wearing, you may think that he's a constitutional court judge. Behind him is Honorable Klopper. On his left is Honorable Murray. Those are the members whom you will be conversing with. We deliberately call it a conversation. Just freely relax and converse. Take your bag to, you can take it to another chair, or you can put it underneath your, thank you. There at the back is Miss Silkstone. She is the content advisor of the committee, and she has a birthday today. Very important, that part. Next to her is Miss Gillian. She is a committee researcher. In front of them is Raja. She's media and communications of the committee. In front of him is, in front of her is Mr. Ramano, the committee secretary, the one you have been communicating with. Next to him is Makadana, the executive secretary. At the back is Mr. Dano, the committee researcher. We are going to allow you time to properly and fully introduce yourself to the committee. I'm deliberately saying properly and fully introduce yourself to the committee. You can proceed.
Thank you, Chair. Good morning, Chairperson, committee members, everyone at large. The name is Nande. Surname is Meshe. I sit at the intersection of law, governance, as well as strategic oversight. I am the director and founder of Meshe Attorneys, private practice in Gqeberha, with a primary base in PE, as well as a satellite office here in Cape Town, where we service the Office of the Consulate General of Angola in respect of cross-border agreements, commercial law agreements, and as well as to give advice in respect of the various legislation that informs both the Republic of Angola and South Africa, because they are subject to the laws of Angola. However, they also employ staff members in South Africa who are subject to the constitution. So ours is to always, make sure that we give that advice in respect of the two pieces of legislation. I provide a governance-centered perspective to regulation. What I mean by this is that I also assist with strengthening strategic oversight. I contribute towards strengthening accountability. I strongly believe in the constitutional imperatives that guide and inform all legislation of this country. Within my private practice, I have been blessed to be exposed to work that exposes me to legislation, interpreting of legislation, regulatory compliance, commercial law, contracts law, I'm very passionate about. And I believe that me having to tender my application to serve is because I do believe that in my strategic basket, I do have the necessary competencies to help the regulator build in respect of its integrity, in respect of its independence, because independence of the regulator is key. It must be protected and it must be seen as protected. So I also strongly believe that I do have the competencies to help build the strategic oversight in respect of the regulator, as well as the institutional integrity as well, because I strongly also believe that I'm one who upholds the values of impartiality, integrity, honesty, and performing my duties without any fear or favor. So that is why I believe that I can be able to contribute to the mandate of the regulator. And I must say, it was very interesting to read up on the mandate, dual mandate, where one side you have protection of personal information, on the other side you have to promote the access to information. And I was like blown away, just taking myself inside the organization to say, I wonder, the little nitty-gritties that come with that interpretation, where we have to close those gaps between the two pieces of legislation, where we have to close out any ambiguities that would lead to litigation, and. So I must say, it's truly an honor just to interact with your pieces of legislation, just to have this dialogue and see where it takes us. So I hope I was able to introduce myself properly and fully. Thank you.
Okay. Also convince us about your suitability to fill the vacancy.
Okay.
Why do you think you are the most suitable candidate to fill the vacancy?
Thank you, Chair. Chair, for me, I think, am I audible?
Yeah, you must get close to the mic.
Okay. So in my opening remarks, I did touch on my value add, what I bring to the information regulator. And I think it is important to also reiterate that in having this combination of law, governance oversight, as well as public sector oversight, I believe that this combination is able to assist the regulator in ensuring that the mandate is upheld. And what I mean by that is that having to serve on various boards within the Eastern Cape province and at national, and also having experience within the regulatory and other appeals tribunals, I've developed a deep appreciation of independence. So I bring independence oversight. I bring, to strengthen the risk oversight, which is also an important element. So I believe that having this three combination of law, of governance, and strategic oversight, I'm able then to also protect and promote the independence and the accountability that comes with the office of the regulator. And having to bring these three in a regulation environment, I think is also paramount, because the independence of the regulator is important. Having to pin that to constitutional imperatives that talk to transparency, dignity, right to privacy. Those principles need to always come through in anything that we do within the regulation environment as well. It will be also important to mention that I strongly believe that my advocacy for agility is important, because we are in an era of artificial intelligence. We are in an era of big data where the regulator needs to be agile enough to respond to the current realities that come with regulating information rights in this era. Recently, now in 2026, there was an issue about artificial intelligence that that was infringing on certain rights of human dignity and privacy. Now we need to respond to that, and the legislative reform is imperative, because we need to be, abreast with all the technological advancements that are also, unfolding. So I bring that culture of agility and fluidity in our leadership, qualities or philosophy. Thanks, Chair.
Are you available to serve full-time or part-time?
Part-time, Chairperson.
Part-time. POPIA requires that members of the regulator must be South African citizens. Are you a South African citizen?
Yes, Chairperson.
Do you hold any dual citizenship?
No, Chairperson.
Are you appropriately qualified?
Yes, Chairperson, I am. I am an admitted attorney. I am an admitted notary public as well as a conveyancer. I am fit and proper, Chairperson.
Can you, in the context of the information regulator, define what kind of a person becomes fit and proper for the, and contextualize it in the information regulator context?
To be fit and proper.
Yes.
For me, someone who's fit and proper within this context is someone who upholds principles of ethical leadership. With ethical leadership, there is a course on ethics when we do our board exams, but that course is neither here nor there. Ethical leadership is doing what is right when no one is watching, is being able to be independent in thought, is to be honest, and to be able not to be influenced by outside pressures as well when you exercise your strategic oversight. So for me, an ethical leader is someone who's acting with integrity at all material times, someone who acts with impartiality without any fear or favor, and someone who's able to account and be transparent. And whenever there's an issue of conflict of interest needs to be declared, and it needs to be transparent, and recusal is also required if necessary. So those are the principles that I ascribe to.
Are there any background issues that may, if appointed, impact your integrity, your impartiality, and your ability to do the work, be it professional, be it financial, be it personal, be it political?
No, not that I know of, Chairperson.
Are you involved in any advisory, consulting, legal, academic, commercial, political, or civil society work that may impede on your ability to do your work, or that may have an actual or a perceived conflict of interest?
No, Chairperson.
If you are appointed and a former employer, an acquaintance, a former funder, or any person who is whom you had a relationship with has a matter before the information regulator, how would you deal with such a situation? There is the matter, it's before the regulator. It involves someone you have had a very close relationship with, be it a former employer, be it an individual, be it a funder, or whoever. Now, you are required to sit to attend to such a matter. How would you deal with that?
I would declare that I know this person according to the example that you've given. I would declare, and I would make sure that such declaration is recorded, and I would ask to recuse myself from the matter.
Thank you. Honorable Klopper.
There we go. Thank you very much, Chairperson. Good day, Miss Meshe. How are you?
I'm blessed, highly favored, thank
Great,
you.
thank you. Ms. Meshe, just a few questions from my side. The first is just a clarity question. I just want to find out you were admitted as an attorney, notary, and conveyancer from 2023.
Yes.
All right. So the vast majority of the experience that you've picked up in all these entities, is it pre your qualifications or admission post, or is it a combination of both?
It's a combination.
All right. In your application, you refer to data protection and the POPI advisory work, right? Would you be able to give us one example of a POPI matter that you advised on? Was it a legal matter, and what was the outcome?
Um, for the protection of personal information?
Correct.
All right. If you recall, in my opening remarks, I did mention that we do work for for the Consulate General of Angola. So having to service that office comes with personal information of the staff members that are employed within the office and those that are employed according to the laws of Angola. So there are several matters that had resulted in disputes internally, where now the Consulate General was conflicted, or rather requested advice to say, Meshe, how do we proceed in this respect? We have received, whistleblowing alerts to say several employees within our office are doing work or performing misconduct within the context of diplomatic protocols. So what she then requested the Consulate General was to say, we want to have access to all the information that they have requested, like in terms of internally IT, the correspondence and all of that. But she just wanted to have access to the information without having to follow due processes. So we had to guide her to say, Your Excellency, there are protocols on how to request personal information. Yes, it's information that you can quickly access. However, in terms of the law, in terms of the protection of personal information, we can't just advise you to proceed with that. So we had to guide her on the conditions of how to proceed in respect of obtaining the information lawfully. We did not say you can't access the information, but there are certain conditions that then allow you to obtain the information lawfully. So that's one matter that we had to guide and provide legal advice on.
And excuse me. Given your current and professional board responsibilities, your practice, how much time can you realistically commit to the regulator, and which roles would you step back from if necessary?
Okay, with how I've structured the practice, I've structured it in a way that allows me to have freedom to do what I want. You would understand that within the legal fraternity, there's diversity, where you're able to focus on whatever it is that you want, a specific niche within the law. So how I've structured the practice is such that it has people that are running the practice even while I'm here, to ensure that the matters that are before us within the context of the practice, they are dealt with. And then for me, I have then been intentional in terms of how I want to profile myself. And what I mean by that is that my specific focus is in respect of corporate governance, is in respect of obviously being a legal advisor, but in respect of commercial and contracts law. So I've structured the practice independent of me so that I'm able to tender applications as and when I feel I'm able to add value to the organization, such as the information regulator. So having to run the practice will not impede me in my functions and duties to serve on the regulator, especially since I then tendered an application to be on a temporal or part-time basis.
And back on that answer, why the IR specifically? What drew you to the information regulator, considering you have expertise in many fields, you are extremely educated? Why IR? Why that?
Because of the uniqueness of the dual mandate, I want to interact with how to navigate that space and contribute, especially now that I have this 3-in-1, which is my legal expertise, my governance, as well as public sector oversight. I strongly believe that the experience that I've gathered serving on all these boards would contribute in ensuring that we inform the jurisprudence of the regulator, we close any gaps and clear out any ambiguities within the two pieces of legislation, and also ensuring that there's harmony between the two, because it must be interesting to have one piece of legislation that promotes personal protection of personal information, while on the other hand, it says allow access to the information. So I'm fascinated in that I'm able to contribute in how to inform the jurisprudence, especially in the advent of AI, the big data, all the technological advancements that are going on. How do you keep up to date, but ensuring that the right to privacy is still intact, the right to dignity, is still intact, and having to balance these two. I'm really fascinated, and I would be honored to contribute in how to inform the legislation and close the gaps and ensure that there's harmony between the two. Yes.
And my last question, ma'am, is if a municipality refuses a PIA request without proper reasons, what should the regulator then consider when dealing with a specific kind of complaint?
It would be important to first investigate. Obviously there will be a complaint. I'm assuming there would be a complaint coming forward where the regulator will have to investigate what process was followed and what were the reasons, and was the person requesting the information afforded an opportunity to be taken through the process. How do you request information? What are the forms that are in place, and what are the timelines? And if there was refusal to provide such access, there should be reasons, and written reasons, to say these are the reasons. Because remember, with the promotion of access to information, there's also the limitation clause in terms of section 36 of the Constitution. So that limitation is allowed to the extent that it is reasonable, it is justifiable in an open and democratic society. So those key conditions will have to be met to ascertain what are the merits before us in respect of this, of the particular matter that you've alluded to.
Thank you very much, and thank you very much.
Thank you.
Thank you, or Mare. We are not ready. Honorable Mutau.
Thank you, Chair. Still good morning, again. Good morning, Ms. Heshe. Meshe. Okay. Chair, only few questions. Now my 3 questions have already been answered. One, POPIA requires responsible parties to secure the integrity and confidentiality of personal information, and to notify the regulator and affected data subjects when there are reasonable grounds to believe that personal information has been accessed or acquired by an unauthorized person. How should the regulator assess whether an organization responded adequately to a security compromise?
All right, thank you so much. I think it would be important to first ascertain the facts before the regulator. How did the information, what happened, the process? Because there are processes to, one, request the personal information. Was due process followed in requesting the personal information? You're referring to the protection of personal information, right? Yes. So there are conditions within the Act that provide lawful process of obtaining the information. So if that was not done, the regulator is empowered to attend to an investigation, to check whether compliance was implemented and proper due process were followed. And in the event that it was not, the regulator is still empowered to refer the matter perhaps to the enforcement committee. And if the effectiveness of that enforcement committee is critical, especially when it deals with complaints and it deals with complex matters. We need to ensure that there's redress and meaningful redress for all the complainants. And the regulator must be seen as independent, must be seen as ensuring that compliance is enforced. And I must mention that one of the powers of the regulator is to ensure that the regulator monitors and enforces compliance both by private and public organizations, ensuring that they are within the parameters of both the pieces of legislation. So it would be important to ensure that any complaint that's brought forward is assessed in terms of the due process that was followed, whether it was lawful, any rights that were infringed, and how does the law protect such.
What strategies will you use to encourage compliance with POPIA by both public and private bodies?
Police. You said police or bodies?
Bodies.
Oh, okay, thank you. You know, as a regulator, the first thing you need to do is to educate, then you guide, and then you enforce. So it is important to spread awareness about the mandate of the regulator, to ensure that you uphold the values and the imperatives of the Constitution at all material times. Now, these talk to the rights in the Bill of Rights. These also talk to the rights in terms of Section 32, which promotes access. Because on one side, you have this mandate to protect. On the other, you have a mandate to ensure that there's a free flow of data. There's a free flow. There are no impediments. So that balance is important. And also, engagements with stakeholders. That's important because that's how you spread awareness about the mandate of the regulator. That's how you also strengthen the integrity and the legitimacy and the public confidence, so that people know, especially the disadvantaged communities that face disproportionate barriers when it comes to accessing or exercising their rights. The disadvantaged communities, they don't know their rights in respect of any law that we have in the country. So it's important to have those continuous engagements to build the trust as well in the regulator from the public, to say, come forward in the event that you feel that certain rights have been deprived. Thank you.
Thank you, Chair.
Thank you.
Thank you. Honorable Matafa.
Thank you very much, Chair. Memeshe, good morning.
Morning, sir.
My questions will focus on the mandate, access to information, and your leadership qualities. So on the mandate, you have touched extensively on the dual mandate. Can you just maybe, in simple terms, if you were speaking to a layman on the street, how would you explain the dual mandate?
Okay. One, let's talk to the promotion of access to access to information. I'll give you an example of someone who has been knocked over by a car. It's a rough matter. This person needs access to the medical records, and they don't know where to go. So in layman's terms, I would then advise the client to say, go to the hospital, go to the police station to request the copies of docket, to request the medical reports. This is the process. The state has a duty to ensure that you have access to the information. In terms of the promotion of access, the state has a duty to ensure that there's a manual, a manual, for lack of a better word, a manual that guides people on how to request the information. Because it's one thing to request the information, and it's another thing to follow due process to request the information. That's one example. On the other side of the protection of personal information, same applies. I'll give you a typical example when it comes to transferring a property in respect of our conveyancing department, when we just before we do the transfer, we have to request FICA documents, personal information, your address, your marital status, and there's a form that we then get the client to fill in, giving us consent. So there must be consent to say you can access my personal information. However, those things need to be ventilated to the client to say, look, we can't just access your information without your consent. So please give us consent. So it's those small things that people think that it's actually rocket science, but it's simple to say there's consent on this side for measure attorneys to access my information. On the other hand, there's a duty on the state to promote and provide access to information within the state.
Thank you for that. The second one around the mandate is just to find out what would you say are the indicators that you can use to assess if whether the regulator is effectively fulfilling its mandate. When you say the regulator is successful on carrying out its mandate, what indicators would you use?
The indicator that I would use first and foremost is the awareness of the mandate. And I'll go back to the disadvantaged communities to say, for me, we'll have to test that in respect of access to information in that context. It's one thing to have access to information and know the mandate of the regulator here in Cape Town. And it's another thing if you go to Edujwa or Emresh and ascertain whether the mandate reaches those people. So that's how I would test the reach, the broadness, the awareness of the mandate in disadvantaged communities. That's how I would test. Two, I'd also test in respect of the complaints that are brought forward, the enforcement committee, how it handles the complaints, how it applies, the turnaround times, how long does it take to attend to complaints, and what mechanisms are in place to ensure that there's openness and transparency throughout the process of the complaint until finality, ensuring that there's meaningful redress for those complainants. Three, I would also test when it comes to the information systems internally, the internal controls. Cybercrime is an issue. What are the controls in place? Is there a risk register that talks to that? Is there a live risk register that tracks the agility or the responsiveness of the regulator to cybercrime, and also having tight controls in respect of their IT and information data? That's another thing I'll test, because we can't say we're not living in an era of artificial intelligence and big data and all the technological advancements that are unfolding. Yes.
Thank you very much. On access to information, you have touched on the Constitution. What would you say that is the constitutional purpose of PAIA?
Which is the
Access to information.
the provisions within our Constitution, or rather, let me say, Section 32 promotes or provides that everyone has got a right to access to information. But then some people then feel, well, perhaps they don't know that even that right is limited. And the limitation clauses in Section 36, to the extent that, the limitation is reasonable and it is justifiable in an open and democratic society. So the right to access is there in the Constitution, and the preamble of the promotion of access to information is informed by Section 32, and we all know that the Constitution is the supreme law of the land. Hence, then the promotion of access to information was enacted to give life to the provisions of the Constitution. So it all ties back to the Constitution, which we need to uphold at all material times.
Thank you for that. I think in your introduction and what Honorable Klopper has raised about non-compliance, you seem to be on the same page that there might be structural barriers to the effective implementation of PAIA in the country. what would you think are the main root causes for these structural barriers to exist? Why is
Within-
it not complied with? Implementation of PAIA, compliance, response to enforcement, and the like.
You know, the issue of compliance, it can't be one cut or, a straight jacket. It depends. On one hand, you have the private entities. On the other, you have public entities who both have a duty to ensure that the provisions of this piece of legislation are adhered to. So for me, you'd have to continuously engage both private and public bodies to ensure that they comply. You have to also have strict measures in place when it comes to perhaps penalties that can be enforced to ensure that there is compliance. Because at the end of the day, we cannot run away from the provisions of the legislation. And it's another thing then to force people to comply. And you force them by ensuring that there are measures in place to trigger any sanctions that come from, non-compliance. So continuous spreading of awareness, continuous engagements with society, international bodies as well that conform to the provisions within the two pieces of legislation that inform the regulator. So it's continuous engagements.
Last one from me, Chair. How you explain the way that you've structured your practice? You seem to be an individual who's not afraid to delegate. If that is your leadership style, please confirm. If not, please take us into your confidence what your leadership style is and how do you think it will contribute to the regulator.
All right. Thank you so much. My leadership style is based on agility. I'm someone who's able to delegate. First, I train, first, I guide, and then after that, then I allow the individual because I've got competent staff within the office to carry the mandate. There's only one measure, and that's the measure that's there and exists is the one sitting here. But I can't do everything. I can't be everywhere. So my systems have to enable my staff to perform without me having to macromanage. I'm not one to macromanage. I know what needs to be done. They know what needs to be done, and then they just execute. So as long as we are all aligned with the principles of honesty, I always uphold honesty within the office. If there's a challenge, escalate it. If you can't manage it yourself, escalate it. If there's conflict, declare it. So always act with integrity at all material times, because with integrity is your reputation, and when you don't have integrity, then there's no reputation to uphold. So those are the values and the principles that I always instill within the practice, to say act with honesty, act with integrity, and act with transparency and accountability, because we all need to account.
Thank you very much, Chair.
Thank you.
Yeah, but I was not happy when you made an example about a Dujwa. Not about big towns like NCOP. Thank you so much. Marie?
Thank you so much, Chairperson. Chairperson, this is not part of what we are here for, but I must say she's a beautiful lady.
Thank you.
Eh? Okay.
You must also be careful because she's also into boxing. Yeah. Be very careful.
Show you she's independent. Yes. Good day, ma'am. How are you? I hope you are rested now after the drama you had this morning. I just want to know, how would you respond if a powerful political figure attempt to influence a regulatory decision? How would you respond to that?
All right. For me, that one, first, if there's a matter before the regulator, which I'm involved in, I'd consider the facts before us, consider the law, what does the law provide, consider the mandate of the regulator and the broader public interest. And then my decision will be based on objectivity and independence, because in my opening remarks, I did touch on the fact that having to serve on boards and other regulatory, tribunals enables me to provide independent oversight. And I love my impartiality. I think that those are one of the reasons why I studied law, because you're able to be impartial, you're able to act without any fear or favor. So I would, just focus on the facts, the law, the mandate, as well as the broader interest of society, and be objective in my view.
Okay, the second one I would like to know, describe a situation where you face an ethical dilemma and how you would handle it.
With ethics, it's so interesting because ethics has no manual. Yes, you write the ethics exam, but ethics is the decisions that you make that enable you to sleep at night. If you can't sleep, then there's a problem. That's ethics. So you must be able to take independent decisions, and account for your decisions so that you're able to sleep better at night. So I would declare, if there's anything that is conflicting me, it needs to be declared. If there's anything that is perhaps beyond me, then I'll have to escalate it. But it's important to act with integrity. It's important to act with honesty, because the integrity is all you have. These papers of LLB and all of that, they are paper if there's no integrity. There's just, so that's how I relate to that topic on ethics.
Okay, so what does good governance mean to you?
Okay. Good governance means having to contribute towards the risk. How do I say this? I want to put it the way I want to put it. Now it's doing this in my mind. But anyway, good governance talks to accountability. There needs to be accountability. There needs to be transparency. There needs to be an agile mind. You need to be agile to react to the current realities, that are informing the regulator today. Cyber attacks, artificial intelligence, big data, and all of that. Are we there? Or are we behind as a regulator? Are we able to emerge and evolve with the technological developments and? So for me, good governance comes with that as well. The integrity of the organization, is it intact? Is it independent? Do we have the public trust? Are people able to say we trust the regulator to be impartial, to be, to act and without any fear or favor? So that's the good governance. Align with the mandate. What does the mandate say? In all the organizations I serve on, I check the mandate and then I align myself with the mandate. So you need to always uphold the mandate, pin it to the constitutional imperatives that inform the regulation of the entire South Africa. Yes.
Okay, what is your vision for the information regulator over the next 5 years?
Over the next 5 years, I would love to see a regulator that is trusted, in its integrity, in its values, what it stands for, the mandate. And I'd love to see a regulator that has harmonization between these two pieces of legislation. So that legislative reform needs to continue to always check, are these two pieces of legislation able to be implemented in harmony, or are they contradicting each other? And if there are any contradictions, let's look into that. Let's emerge with the times as well in respect of AI. Are we, cutting edge or leading within the cutting edge developments in respect of the technological space? Are we there? Are we independent? That independence is important because, one, the regulator must be independent and it must be seen as independent. It's one thing to be independent, but does the public trust that indeed the regulator is independent? So I would love to see a regulator that is premised on those values enshrined from the Constitution: independence, accountability, transparency, and evolving with the times, especially in respect of the information data that's going on.
Okay, I hear what you're saying. Why should Parliament recommend you for the appointment?
It's because I bring a governance-centered perspective to regulation. I strengthen and I assist in strengthening the institutional integrity of the regulator. in my strategic basket, I also have independent oversight. I'm an independent thinker, and that's important here. It's important to consider other views, but it's also important to have that independent thinking and leadership quality. I bring integrity. I bring honesty. A spade is a spade. In any context, it depends in that context. But I bring impartiality, I bring honesty, and I bring agility. I love pressing restart. If it doesn't work, I press restart even now. So I bring that to the regulator, and I do look forward to help to contribute to growing the regulator to be one that is trusted, respected as well, and also legitimate as well. So that's my story.
Thank you, Chairperson. You got beauty and you got brains. Jay.
Thank you.
Thank you, Honorable Marie. I won't comment on the last part. Ms. Umesha, Section 55, subsection 1 of the Constitution accords powers to the National Assembly to enact or amend the national legislations. What improvement would you advise Parliament to do to both PAIA and POPIA in the advancement of a better work of the information regulator?
All right, thank you, Chair. I would advise Parliament in respect of legislative reform. The current legislation that guides the regulator needs to be clear in respect of the mandate of the regulator. What I mean by that, the independence of the regulator needs to be protected such that there should not be any contradictions between these two pieces of legislation and your PFMAs, for example. So mine would be to give advice in that respect, in respect of the legislative reform. There needs to be cleaning up of the legislation so that we even mitigate the risk of litigation. Because when you have lacunas within the law, there's a risk of litigation. When there are gaps, when there are ambiguities, contradictions. So for me, I would just advocate for the independence of the regulator, making sure that the regulator is clear where it accounts and there no other legislation that contradicts the mandate and the independence. That would be my advice.
Thank you so much. That takes us to the end of your conversation with us. You can take a sigh now. Say, so we thank you for raising up your hand when we are looking for patriotic South Africans to go and meaningfully contribute to the public service on behalf of the people of South Africa. We are going to set a date as the committee, deliberate on the interviews, make a recommendation to the House after having adopted the committee report. Then the House is going to do the honor of adopting the report with the recommendations. We'll keep in contact with all the candidates through our committee secretary. We wish you all the best, and we wish you a safe travel back home. Are you going back to Gqeberha?
Yes, but not today.
Oh, okay, that's fine then. So thank you so much. We wish you a safe travel back home, even if it's after a week. Thank you so much. You are excused.
Thank you. May I just have one
Yes, you
closing
can.
remark? Mine is also just to give thanks, Chairperson. It's truly an honor. I don't take it lightly because sitting here and having this dialogue on its own is just a blessing for me. So I do appreciate this opportunity. Thank you, Kakun.
Siyabulela, enkosi, uhambe kahle.
Thank you.
Members, that's how we close the chapter of interviews for the information regulator. You switch it off, please. Yeah. So, for the week we're done. Except myself and Honorable Glober, who still have got a baggage of the ad hoc committee for this week and next week. Also, I'm told that next week Parliament will be on recess, I think. Then we'll come back the other week. But what I want to do now, immediately now, is to quickly convene my management committee to deal with issues of the next term. So that when new members come back from the recess, there is a solid program for you to execute. So I'm not sure about lunch. What's the issue about lunch? Where is Mr. Raman? So, okay.
Chair, just in your indulgence, I just want to find out the process forward on the information regulator. How long should it be before we deliberate on that specifically, or will that also be discussed in the management?
Yeah, we'll add it in the program we are to craft, but it should be as soon as you can, because you'll recall that the chair of the regulator has been complaining about how these vacancies make them work and operate under difficult circumstances, to an extent that they would even fail to reach quorum, so they wouldn't be able to work and all those things. So we should ensure that we are quick in dealing with it. Thank you, Honorable Klopa. No, Mr. Ramano is going to brief us on where the lunch is, but you are excused, Honorable Mare, Honorable Klopa, and Honorable Mutaung. We are starting another meeting of the management committee. Colleagues, can you come closer? This thing of being far is not going to work.